Hello friends, welcome to Indic Law. You may have heard about the Armed Forces Special Powers Act or AFSPA, which is back in controversy after Indian Army's para-commandos shot civilians in Nagaland's Mon district. The government has described the incident as a case of mistaken identity. Let's learn a little bit about the origin of AFSPA. AFSPA is directly connected to the Naga freedom movement. In 1951, the Naga National Council (NNC) had conducted a plebiscite in which 99% of the Naga people voted for a free sovereign Naga nation. Thereafter, they boycotted the first general election in 1952 and later extended the boycott to the government schools and officials. In 1953, the Prime Minister of India, Jawaharlal Nehru, and the Prime Minister of Burma, U Nu, visited Kohima. Around 15,000 Naga walked out of the public meeting place when the administration did not allow NNC to submit their memorandum to the Prime Ministers. An arrest warrant was issued against NNC leaders after Nehru's return to New Delhi. The Assam Maintenance of Public Order Act of 1953 was promulgated in the Naga Hills district and declared as disturbed. Following this order, the Assam police and paramilitary forces began to arrest and torture many people at random, forcing many Naga leaders to go underground and take up arms to defend themselves. The situation worsened when the Assam Disturbed Areas Act of 1955 was made harsher under the name of the Armed Forces Assam and Manipur Special Powers Act 1958. So what is AFSPA? As we learned, the AFSPA or Armed Forces Special Powers Act 1958 was enacted amid the nascent Naga insurgency, giving powers to the army and state and central police forces to shoot to kill, search houses and destroy any property that is likely to be used by insurgents in areas declared as disturbed by the Home Ministry. Security forces can arrest without warrant a person who is committed or even about to commit a cognizable offence even on reasonable suspicion. It also protects them from legal processes for actions taken under the Act. Which states are under AFSPA? In the Northeast, the AFSPA is in force in Assam, Nagaland, Manipur excluding Imphal Municipal Council area, Shanglang, Longding and Tirap districts of Arunachal Pradesh and areas falling within the jurisdiction of the 8 police stations of the districts in Arunachal Pradesh bordering Assam. For Jammu and Kashmir, the Armed Forces Jammu and Kashmir Special Powers Act 1990 is in force. Initially, it was meant only for Assam and Manipur, where there was an insurgency by Naga militants. After the reorganization of the Northeast in 1971, the creation of new states like Manipur, Tripura, Meghalaya, Mizoram and Arunachal Pradesh paved the way for the AFSPA to be amended so that it could be applied to each of them. The amendments contain different sections as applicable to the situation in each state. How is a region declared disturbed? The state or central government considers those areas as disturbed by reason of differences or disputes between members of different religious, racial, linguistic or regional groups or castes or communities. The state governments can suggest whether the act is required to be enforced or not. But under Section 3 of the Act, their opinion can be overruled by the governor or the centre. Section 3 of the AFSPA empowers the governor of the state or union territory to issue an official notification in the Gazette of India, following which the centre has the authority to send in armed forces for civilian aid. Once declared disturbed, the region has to maintain status quo for a minimum of 3 months, according to the Disturbed Areas Special Courts Act 1976. Now let's look at the arguments for and against AFSPA. The army is opposed to the withdrawal of AFSPA. Many argue that removal of the act will lead to demoralizing the armed forces and see militants motivating locals to file lawsuits against the army. Critics say the undemocratic act has failed to contain terrorism and restore normalcy in disturbed areas as the number of armed groups has gone up after the Act was established. Many even hold it responsible for the spiraling violence in areas it is enforced. The Supreme Court, in its decision in the case of Naga People's Movement of Human Rights versus Union of India, upheld the constitutional validity of AFSPA but laid down certain guidelines in the form of do's and don'ts. Justice Jeevan Reddy Committee was set up in 2005 to review the AFSPA after the killing of Thangjam Manorama Devi in the year 2004. The committee recommended that some provisions of AFSPA should be transferred to Unlawful Activities Prevention Act 1967 and even asked to set up an independent cell which will be called the grievance cell that will do the work to inquire into the complaints filed for violation of basic human rights. Do you think imposing AFSPA is justified? Do you agree that on account of continuous human rights violations being reported in the name of security, the AFSPA should be repealed? Share your thoughts about the AFSPA in the comment section.